Welcome to StarTalks powered by AdvoTalks. Today, we have with us our esteemed guest, Ms. Jasmeet Kaur, who is a highly accomplished legal consultant with a specialized focus on corporate law, tech law, and data privacy. Ms. Jasmeet offers valuable expertise in aiding startups and businesses with contract drafting and legal research. She has demonstrated her ability to provide strategic legal counsel tailored to the industry and is adept at conducting thorough reviews and enhancements of e-contracts, proactively mitigating the risks associated with online operations, and designing and maintaining the legal frameworks in alignment with the organizational objectives. She and her role as a catalyst for the success of partnership is very prominent, along with her meticulous handling of legal documentation from the inception to the validation of such e-contracts. Her skills in the contract drafting and corporate law are well recognized, and she has proven record of crafting essential documents such as SaaS agreements, statement of works, privacy policies, non-disclosure agreements, shareholder agreements, and many. Her unique approach to legal consultancy brings immense value to the businesses, as her commitment to mitigating risks and fostering strategic collaboration is evident in her work. She stands out as a seasoned legal consultant dedicated to empowering the businesses through tailored legal frameworks, and her comprehensive expertise makes her an authority in the legal field. Today, she has joined us at StarTalks to express her views on the 7 must-have contracts for the startup founders. The wait is over, and I am quite thrilled to host her. Welcome to the show, Ms. Jasmeet Kaur.
Thank you, AdvoTalks, for having me. And I'm pretty much overwhelmed with the introduction. It would be my honor to give you the understanding that you're looking for in 7 must-have contracts for the startups. Thank you again for having me.
It's quite exciting for us at AdvoTalks, and let me get into the queries one by one. And let us start with understanding on the founders agreement. A fundamental understanding is what we are looking at the moment, Jasmeet. So, can you give us an understanding on the founders agreement? Like, what are the key elements a founders agreement should be covering when we are drafting things like ownership percentages, and then the decision making, as well as the dispute resolution provisions? And also, how important is the founders agreement in place before launching the startups?
So you have partially given the answer in the question itself. But yeah, a founders agreement is the foundation of every startup. It's must to be there. No matter how small the detail it has to be mentioned in the agreement. It is to be listed in the written documentation. Now, if I have to talk about the key elements, there are a lot, but the very, very basic ones. First of all, it's ownership, like you mentioned. It's very important to just write it down. What are the stakes of the co-founders? Then we have the roles and responsibilities. One of the very, very, very important clause, because a lot of disputes arise because of that only. It should be very clearly listed what you and your co-founder are doing. Who is going to handle the finances? Who is going to handle the clients? Who is going to do the outreach purposes? If you are a startup with, let's just say, technology, who is going to do the coding? If you're going to hire someone for that, and who is going to manage that person? No matter how minor the detail is, it is to be listed. Now we have the dispute resolution. If something happens between you and your co-founder, what will you do about that? Will you approach the court? Will you go for arbitration? Will you try to resolve it amongst yourself first? That is to be listed. Or will you have a mediator as well and try to just have an out of court settlement? That is to be listed. Then comes with the confidentiality. That is very important. And this is one of the major reason, like you mentioned, that why the startup should have a founders agreement before launching the startup, then confidentiality is a very, very important reason. Now, what will happen? Let's just say if you and me, we decide to come into an agreement, we start a startup and we just go, discuss everything. Then I change my mind. No, I'm not going to work with you. I just go and give the idea to someone else. I go to my best friend and say, okay, let's just start the business. I already have an idea. Now, what will happen? Your idea has gone already. You cannot do anything about it. That is the reason a founders agreement is important. And even let's just say we need an investment for that. Why would someone fund our startup if we do not have anything in our place? They would firstly ask us what are our stakes in the startup. What we will say, it's not decided yet. even if I forget that at a moment, then even if we have a startup, we just started and it's going well, we decided, okay, we will do 80-40, we will do 80-20, we'll do 60-40, whatever we have decided. And now the startup has boomed. We are making in crores. Won't you come and say, if you are the 40% of partner, I am the one at 60%, you'll say, no, let's do 50-50. Why would I earn less? So these are the kind of things that have to be mentioned. I then of course there is an exit strategy that is must to be there. What are the buyout options? What will happen if you decide to just sell your share? Will I have the right of first refusal? So these are some of the things that have to be mentioned and should be taken care of.
Yeah, looks like there are multiple aspects that we are going to address through the founders agreement, as you mentioned. More of an kind of, consent and what is the agreement between the founders that is going to be the base, as well as it's going to address in certain dispute, resolution aspects, as you mentioned. So definitely, no one would want, any particular party to between two parties. There should be a litigation. But if given such kind of a situation, probably founders agreement is going to be off rescue if proper terms and conditions are drafted. So I could get that essence out of what you have suggested. Jasmeet, so let's move a little bit ahead and then try to cover the aspect of the intellectual property right assignment agreement. So according to you, what type of what types of intellectual property does the IP assignment agreement actually cover? Like there are multiple types, like trademarks are there, and then the copyrights are there. So for what all aspects this can be used as a legal document and instrument, and how does the IP assignment agreement ensure the startup owns the IP created by the founders, or for that matter, the contractors involved?
So that is the whole purpose of an IP assignment agreement, to ensure that whatever the intellectual property is owned by the startup and not by any of the employee or the founders or anyone else. Now, if I talk about what kind of intellectual property is covered, it will be everything, be it copyrights, be it trademarks, be it patents, inventions. Everything is covered in the IP assignment agreement. A very big example, we can take Coca-Cola. What the taste of Coca-Cola is, it's not there with the founders. They do not have the right of it. It's with the company. So that's what an IP assignment agreement does. It gives you certain rights, and it especially gives the right to the company. Like if I am a lawyer, I work in a law firm, I get some clients. The clients will belong to the law firm, not to me. And if I decide to leave the law firm, the clients will not come with me. They will stay with the law firm. So, if even if I talk about the copyrights and trademarks, then of course, let's just say I have hired someone to build my website. Now that person have developed it. That does, and ultimately he have put in the work to design all the codes, to design the website. But I have paid him a consideration to get the website for myself. So that is but obvious that I will own the IP. And that's what IP assignment agreement does. Gives you the ownership.
Great. I mean, like in lot of aspects, like when one person is actually given a fair consideration, I think like the IP rights will not be there with that particular person, but the person who has funded. I think it is very clear after this conversation. And thanks for bringing the case study like Coca-Cola. We really appreciate that in giving an understanding on the IP assignments. And it typically has a wide application, as I'm getting while I'm talking to you. Let's move ahead and understand a bit on the non-disclosure agreement. This is quite a kind of appears everywhere in the corporate, that I wanted to know, like when is it essential to use a non-disclosure agreement, especially like discussing ideas with the potential investors and partners is something that I feel. Do you see that any other areas the NDA should be kind of used and utilized, and what are the consequences of breaching an NDA? Like absolutely a kind of agreement between two parties. So up to what extent the consequences can actually lead the other party to?
Okay. So if I talk about the NDA, and it's a non-disclosure agreement. That means whatever information will be covered in an NDA, that will be confidential. And it could be anything or it could be everything. That ex- that entirely depends upon your startup. So let's just say if you are discussing your ideas with your co-founder, And like I mentioned in the co-founders agreement as well, you need to have a confidentiality clause. And in India, what it does, it just broaden the horizon. So it lists everything down in detail, that whatever the discussion you have, you're not allowed to share it with anyone. So, and then coming forward with it, then of course, if you have any of the discussion with the investor, you can keep it confidential. NDA helps you protect that. If you have hired someone to build something for you, you can have it confidential. So these are the things that could be keep. And if I generally speak, it could be like anything or everything. It entirely depends upon your startup. I once worked with one of the startup, and they actually had a dispute about that. He have hired someone to develop his website, and what the person did, he just leaked the codes, and that is going to cause my client millions, because ultimately you have the investors in place, and if they got to know that their codes have already been sold in the market, then of course they would not have invested in that. So that, and then after a year of working with the developer, when the developer finally leaked his codes, then he come to know that yeah, I need a non-disclosure agreement, and then he came to me, and then we drafted a non-disclosure agreement for him. And if I talk about the consequences, so if it's an online breach, then we can issue a DMCA notice. And of course, we have the legal remedies. We can sue that person for damages. And we can also have the injunctions. We can just injunct the party not to do it further. So these are some of the remedies that we follow. And of course, its extent, it depends how grievous the breach is. And on that basis, we take into account what exactly needs to be done over here.
Absolutely, absolutely. So it definitely will start with some kind of notices, and as you mentioned, if the person is continuing the breach, that's going to be kind of add to more of a liability on that particular party. So definitely the petitions like injunctions are going to be of rescue for the other party or the founding party. Thanks for bringing the live cases where some of the tech oriented startups may actually be facing these kind of issues. So let's move a bit on the aspect of the full-time employment as well as the contract employment. As a startup founder, I would be looking on to which one is suitable for myself. So I wanted to understand a bit on the contractor agreements part. So the key differences between an independent contractor agreement and an employee agreement is what I wanted to understand from you, Jasmeet. And also, can you help how the contractor agreements are going to help manage the project scope and ensure the deliverables are met?
So if the startups are a bit confused about whether they should go for a contractor agreement or an employment agreement, and most of the starters do prefer contractor agreement. The reason being, they do not have a lot of funds if they are in initial stages, so they would not like to invest in the employees. Now, what is the difference between employees and contractors in the first place? Is employees does have a lot of benefits, like they have the insurances, they get paid leaves. The contractors do not get that. They only get the money for the things they work for. If I am a startup founder and I have some of the work, and it's but obvious I may have client today, I may not have the client tomorrow. So I would prefer a contractor over an employee, so that I will not have to pay anyone the paid leaves. Then there is this thing that the contractors work independently. They do not have anything, let's just say a company policy governing them, that they have to work in this specific thing. Of course, if it's there in contractor agreement and every scope is listed, then they will have to comply with that. But as specifically, they do not have to comply with the company's policies, whereas the employees do have to comply with that. Then we have the taxes. Yeah, if there is employees, then it's the responsibility of the company to handle their taxes. Whereas in the case of the contractor, it's the contractor who pay their own taxes. Because of course, in companies they hold the taxes of the employees and then they take care of that. And the second question that you asked about that, so how the scope is governed in the contractor agreement. So that is pretty much listed in the agreement. What are the scope of work? What exactly the contractor have to do? What are the timelines? And what are the milestones that have to be achieved in the timelines? What the payment schedules will be like? It could be bi-monthly, it could be monthly, it could be milestone based. That are very specifically listed. What will happen if the performance standards are not met? The company or the startup can decide to pay or can decide to deduct, or they cannot even pay any if the work is not up to the mark. So everything is listed in there and the contractor have to comply.
All right, that gives us a good, demarcation. Like you mentioned, an employee agreement is going to be a standard one across the kind of organization. But as you mentioned, like some contractors may be coming up with the specialized skills, and then we may want to kind of treat them with some particular emoluments or the benefits, like you mentioned. And some of the contractors need not be kind of provided with such benefits. I guess that tailor-made contractor agreement is something that is going to be of rescue for the startup founder. And also, as you mentioned, whenever we are trying to kind of enter into particular contractor agreement, so we are expecting the project scope to be covered by that particular party. So as you mentioned, if we kind of draft them down into the contractor agreement, it is definitely going to be helpful in the governance of the project, as you mentioned. So I am trying to little bit dilute our understanding on the startups, products or services. So where I am visualizing and understanding on something which is related to the terms of service, the TOS, as we mentioned. So what does this terms of service typically outline for users of a startup's product or a service, and how they can be kind of clear and concise terms of service arrived to protect the startup from legal liabilities, for that matter. Jasprit.
Okay. So a terms of service should be very clear. It specifically list what are the user guidelines. If a user is coming to your startup, let's just say if you have a technology startup, of course it would be online. So if they're coming to your startup and using a service, it has to be very clearly listed what the guidelines are. Like the very biggest example I can think of at the moment is ChatGPT. If we just go and search something over there, it's specifically listed that do not enter your personal information. It's the guideline. Now, if you enter your personal information, it gets leaked. ChatGPT will not be responsible for that. Now, uh, uh, whenever it gives you a result, it specifically states that if the information you can cross check from the other sources, do not rely on this information. So, of course, that has to be listed. Now, then, what the users can do exactly on the website. So, what are the services the users can enjoy? That also has to be listed in the terms of service. Then there are other things like the limitation of liability. There is a maximum cap on everything. If we buy a product from market, or yeah, and if you read its user manual, there will be always be a clause of limitation of liability that states that whatever happens to your product, or whatever happens with you, you will only be paid the amount your product cost. So if I'm buying something for 50,000, I cannot go ahead and claim 2 lakhs for that. Of course, if there is something a major issue and the case goes to court, then it may vary, but they limit their liability. They have the cap that you cannot get more compensation than this specific amount. So this is what a terms of service does.
You have taken the example of ChatGPT wonderfully, that before we start using itself, the service provider is very kind of taking care of those terms of service, and then he tries to give us that information in advance. And like you mentioned about limitation of liability is also something that it quietly kind of falls into that category. I really appreciate you bringing up the real cases that is really disruptor today in the technology aspect, the chat GPT. And let's dive into the aspect that you have mentioned in the usage of the chat GPT itself, that chat GPT attempts to say you tell you that whatever kind of information that you are feeding in or keying in, it's kind of if it is very sensitive, you don't do it, right? And also says about the limitation of the liability. So there are a lot of privacy concerns that we kind of see these days, and then the startups which are associated in the technology space are also kind of facing numerous challenges. And I would definitely kind of refer back to the instances in 2021 where firms like Meta were kind of challenged in the courts of law. So, Jasmeet, help me understand, like what kind of user data does a privacy policy typically address, and also like how to ensure that the privacy policies comply with the data protection regulations. We have multiple data regulations like GDPR, and how to align our particular, operations with the regulations in place, Jasmeet.
First of all, a privacy policy addresses a lot of information. The very basic one of which is personal information. whatever it collects, whether it collects the name. These are actually very basic things. Every website collects that. Your name, email address, phone number if you give it to that. And if you have permitted for the location, then the addresses. Then we have the sensitive personal information. This information is not collected by every website though, but some of the websites do collect that. It includes the payment information, and sometimes it includes that do or does not even fall in the sensitive personal information category, the URL you are coming from. So some of the website, what they does is they collect the URL of the website that you have come from and the URL of the website that you will be going to, just to manage the things or track the services. Then, of course, if I'm talking about the tracking, then the privacy policy does talk about the cookies and tracking technologies as well. Whether the website or the startup is using cookies, whether they're using web beacons to collect the information or to track the service, to track whatever whoever is coming to the platform. And of course, some startups do have a lot of cookies, so they have their separate cookie policy as well. But those are essentially mostly covered in the privacy policy only. And one thing that need to be mentioned, that need to be considered in a privacy policy is what, why, and how. What kind of information is collected, why the information is being collected, and how it will be used. That is what we do to comply with the regulations. So we have the three basic regulations in place. First is GDPR, that is governed all over Europe. Then we have the CCPA in the California regulation, and now we already have our own India's Data Protection Act, that is the DPDPA. So to comply with that, we need to take care of these things first. Then we need to give all the remedies a consumer or a person, a user can have if he or she comes to our website. And they do have various rights that has to be mentioned, like the right to erasure, the right to correction. Now India have a different right, a very unique right that none of the regulations have, the right to nomination. These are the kind of rights that are to be specifically listed in the privacy policy. And of course, the grievance redressal mechanism or the grievance redressal officer. If a person have the grievance, he or she want to reach out to you, how can they reach out? That has to be listed. When the privacy policy was last updated, that has to be listed. And yeah, now we have the children's protection as well. So if the children are coming to your website, what measures are you taking for that? Now, if what exactly are you doing for the security? If someone is coming to your website, how secure do you feel they are? If you breach something, what if the data is leaked? What kind of measures you can take for that? So everything has to be listed in a privacy policy to comply with the laws.
Great, Jasmeet. I think you have rightly segregated the type of user data, like you mentioned, the basic fundamental information, which may be just about your name and email address, as well as to some extent the sensitivity may be increased, like in your aspects like location, address, and the phone number, like you mentioned. And also how different companies actually try to kind of take some information of URLs that you as a user has actually entered. So I think these are something that as an end user, if we are kind of having an idea, definitely this is going to be useful. But for a startup founder, definitely privacy policy is something that should be in place and should give the consideration for all these aspects. As you mentioned, the protection of the children's rights is something of a major concern today for the society, that should also be taken care. And all other aspects, like you mentioned, like the reference to the regulations as well as the grievance redressal mechanism, and all this should be addressed, is quite insightful for us, Jasmeet. Let's move a bit about probably taking the last type of legal document, which is about the bylaws. What role does the bylaws play in the internal governance of a startup, especially? And how often should the bylaws be revised and updated, Jasmeet?
So bylaws are all about the internal structure. Whatever the things you want that are to be discussed in your startup, what do you think should be followed by every of your employee or every of your founder? That is to be listed, like the voting powers that can be listed in the bylaws. And if I and the powers of the directors that could be listed in the bylaws. So everything, every minor detail of the internal structure that could be listed. And if I have to talk about the amendments, there is no hard and fast rule of how bylaws could be amended. It could be annually. If there is some major change, like the change in structure, I have an LLP first. Now I'm proceeding to the company. That changed the structure. I can change the bylaws now. And yeah, and also one more thing, it's not important that you change the entire bylaws. If there is some minor change, then what people does or what the startups do, they just have an addendum. They will just list that specific thing, that this thing is changed, and they will attach it to that specific bylaws, and that's it. That's done.
Makes sense, makes a complete sense to understand, what are the requirements that we internally feel for the governance of a startup is something that should be listed out. And if there are any key milestone changes, definitely those should be kind of, recorded, and the bylaws should be updated and revised as you have suggested. Jasmeet, I think like this almost brings to the end of our conversation, but I'm very curious to know from you, what kind of biggest legal mistakes that startups can actually get into when they kind of, are dealing with the contracts that we have been speaking about. And also, do you have any final recommendations for the founders out there navigating the legal landscape? Jasmeet.
There are two major things that I have faced while working with the startups. First thing, they think documentation is not important. We'll do that later. The very first thing. And the second thing is, even if they do have that, they have a very vague agreement in place. What they do is, now that ChatGPT is in place or various AI tools, they just go and say, draft me this privacy policy. You will see it's just like one pager. It has nothing to comply with the laws. It does not provide anything that can help them to just give users the clarity and comply with the laws. Nothing. So that thing I feel that the startups should take into account, to have firstly just discuss with a legal counsel. What exact, if you are starting something, it's better to be safe than sorry. Then just discuss the things with the legal person, with the legal advisor, something that, okay, I'm starting this startup. What are the laws I should be taking care of? Should I be complying with? What the agreements do I need to have in place? What are the kind of licenses I need? Everything has to be discussed. Then, even if you do not want to reach out to a legal advisor, do your own research. It will surely take a lot of your time. Maybe you can build an entirely different code in that time. But even if you do not want to, you want to save your money, but you need to know what exactly legal liabilities you could face in future if you do not comply with that. But do not just go into the vague agreements. It could lead to serious trouble. Let's just say if you are drafting a privacy policy, and in the sensitive information you say that I collect your card information, and in the card information I do collect the CVV as well. That is not collected by anyone, and that could lead you in serious trouble. How can you collect someone's CV, or how can you collect someone's passwords? So these are things that has to be taken care of. Some of the startups, or if they have to collect some sensitive information, I mean, they could collect the card information, everything, the account number, the CVV as well, but they cannot store that. I think I just said something completely different over there. So just to be sure about that, that this information cannot be stored.
Absolutely, absolutely. Thanks for giving that clarity that can be captured but cannot be stored. The particular financial information like CVV is what you have mentioned. Definitely, that makes a lot of sense, and definitely it's a kind of learning that the capturing of the data is a different mechanism when compared to storing of the data and then possession of that particular data. In the terms of the GDPR regulations as well, these terms are exclusively defined and or governed by these regulations. Thanks for bringing that, Jasmeet. The technological upgradations like ChatGPT are going to be useful for fundamental nature, but there is definitely a need for a review by the legal counsel or consultant or the advisor, as you mentioned. So the founders should actually be very cautious about the drafting of these kind of contracts or the legal instruments, and it is always advisable for them to approach a legal counsel. I think like we have really formed a quick capsule of the 7 must have startup related documents, right? And the agreements, especially the legal documents that the startup should be having and possessing. I think like I personally feel I don't want to close this conversation, Jasmeet, frankly, but this brings us to the end of the conversation on these particular must-have contacts. And thanks for giving time for our audience understand the various aspects of these must-have contacts for the startups. We appreciate your time taking for our talk show, StarTalks, powered by AdvoTalks.
Thank you for having me again.
So, viewers, that's about today's episode with Jasmeet Kaur, which brings a lot of insights on the 7 must-have contacts for startup founders. We hope the conversation was informative. And for more updates and information on legal concepts, please visit our website www.advotalks.com. And don't forget to like, share, and subscribe to our YouTube channel, AdvoTalks.